is that when it says you can't prohibit it, that doesn't mean you can't pass a zoning bylaw that limits it to certain areas. But in our view, it does mean that if you have no mention of this particular use in the zoning bylaw at all, then the argument can be made that it can go anywhere. What do we base that on? By analogizing it to other zoning issues. For instance, adult entertainment districts. People haven't liked to hear it, but we've told people, you know, if you don't allow it anywhere in town, somebody can come in and say they can be anywhere in town.
The use of the exemption and this hot topic around it, municipalities trying to sort it out, that does date to much more recent. It's been the last 2 or 3 years where municipalities really have been trying to figure out exactly how to apply regulations under the long-standing solar exemption. And yes, the federal and state governments and others have been offering incentives for solar that have folks basically trying to deal with what does this exemption allow us to do or not do under the, and so that acknowledge. And I would also add that given the state of affairs, we do encourage municipalities such as Carver to basically get some regulations in place. We do think you need to have something, because having nothing means there's all kinds of uncertainty around what conditions apply and don't apply. And certainly we would encourage Carver and all municipalities to adopt some regulations around solar energy systems. And details that are sometimes difficult to sort out. We do think you need to have something in place to be organized.
If a developer comes into your community and starts waving a statute around, saying we're exempt, we're exempt, we're exempt, run. Because that is not a developer that you want to be doing business with. That's not a partner. That's not a way a partner would situate his or herself with a particular community. Those who are responsible are not going to be afraid of regulation, as long as that regulation is reasonable, based on good, sound, prudent standards, and things of that sort.
Looked at dozens of solar bylaws. Many of them do, most of them do break solar PV into 2 scales, 250 kW and above and small scale under. There are some that break it into more tiers than that. They're kind of rare. There are bylaws that do require minimum lot sizes, as was suggested over here somewhere earlier, 5 acres, 10 acres or more. There are some that do that, require a large parcel size in order to have solar PV. There are widely ranging setbacks. I'm usually not part of the conversation as to how the setback was set in the first place. I don't know why the community picked that. Yes, I can guess some of them were picked for some of the reasons that are being talked about here, to deal with abutter concerns, things of that nature, but I'm not usually part of the politics at the local level as to how that setback was picked. I can give you bylaws adopted by others that can give you a sense of the range of setbacks other communities have considered, but I can't speak to the politics behind them.
I was just sitting here, I brought about 5 or 6 bylaws from other communities, flipping through to see. And it ranges. First of all, I think, to be honest, most of the communities that I've looked at here use that model bylaw as a starting point, and so they tend to follow what's in there. Unless, frankly, my impression is that you're probably giving this a whole lot more thought than some other communities have, and that's a credit to you.
There is no doubt.
I see 25-foot setbacks here. I see 75-foot setbacks. From my point of view, in reviewing a bylaw, I don't care so much. I mean, I don't have personal idea on it. I'm just looking at it from a legal angle. And the legal question is, what is reasonable? What's a reasonable regulation? And having a minimum lot size is probably reasonable, unless you said it's got to be 1,000 acres, and there is no 1,000-acre parcel in town to put it, then that would become unreasonable. But something like allowing it, and you could have the setbacks and the minimum acre size could differ from zoning district to zoning district. You have to be, the rule is it has to be uniform requirements within a district, but you could have slightly different requirements. So it might be in an industrial area, you're not so concerned about the buffer and the setbacks as you would be if it's going to be in an area where there are residences around. So again, I just sort of encourage you to think about what the purpose is, what the problem is you're trying to solve. If there's a rational reason for what you're doing, I'm confident that if it came to a challenge, the court would uphold it. And that's the way I look at these things.
I've seen projects in 7 communities, and what other people have said, they haven't approached it with the clarity and the breadth of inquiry that you all have. They focused on 2 things that I saw: a sort of intuitive sense of size, which you said 250 and above, but they weren't necessarily clear about it. And the second issue was what Mr. Weston mentioned, and that was that they were trying to avoid the law of unintended consequences. They were trying to not restrict individual rights while achieving the good of the community. It's a messy process. This is new. I mean, a lot of this is new stuff that these laws were not necessarily created for. So it's not quite, I don't know. It's more like you're at the bleeding edge, not the leading edge. You're ahead of everybody else.